All right, we have one more chapter to do, but it's a much shorter chapter. So I still anticipate being done early, like maybe in a half hour. That still gives you a half hour, 40 minutes of class time to hopefully meet. I'm sensitive to that, and I want to give you that time because for those of you that came in late and can't read the board, presentations and written assignments are due in 2 weeks, so do use that time wisely. So let me not waste time, let me jump right into landlord and tenant law. So we're still talking real property, but if I wanted to make an analogy, bailments are to personal property what landlord-tenant law is to real property, right? Because here we're talking about not ownership of real property being transferred, but we're talking about use being transferred. So no, I think we've had enough of this terminology of estates and freehold estates and so on. But this is a legal definition of landlord-tenant law. All it means is that the owner of real property, the landlord, gives the tenant the right to use that property for a period of time, even though the tenant does not have title or ownership of the real property, right? That's what the landlord-tenant relationship is. And by the way, it doesn't have to be just for residential use, right? This is business law. It can also be, of course, for business use. So, who is a landlord? The landlord in a lease is called the lessor, who transfers the property in the lease. The tenant is the lessee, the property to whom, the party to whom the property is transferred for use. I mean, of course, we'd love to name the parties. You can call it landlord-tenant, you could call it lessor-lessee. And again, that's just the way it is. What is a lease? Again, a lease is an agreement. It's a contract, isn't it? Right? Where the right to possess and use real property for a period of time has been given to the tenant by the landlord, and it's basically an agreement between them. Right? It's a contract. You can't get away from contract law. And I think the next slide is just a very nice summary of the different types of leases that are out there. And this is when people really start to get annoyed because we talked about ownership interests as joint tenancies and tenancies in common. And here the same terminology comes in, but that was ownership and this is leases. I can't help it. That's just the names that have been around and they haven't been changed. So here when I talk about tenancy, I'm talking about a lease. Different types of lease. Who's ever signed a lease? There you go. Right? I'm assuming you've signed lease for places to live, not for places where you run a business. But remember, it could have been, right? So, someone signed a lease for a certain period of time? A year, that's typical. Guess what? You sign a tenancy for use, right? Because this is where the landlord and the tenant agree for a specific time of the lease, right? And one thing I want to highlight, tenancy for years is a very bad name because it implies that it has to be for at least a year. But that's not true. You could sign a 6-month lease, a 6-month lease, a 9-month lease, but it would still be a tenancy for years. Just because it said tenancy for years doesn't mean that the minimum term has to be a year. The definition is that it is a lease for a specific period of time. Nobody said the law was straightforward. It has some nuances to it, okay? All right, there are other types of leases as well. For example, a periodic tenancy. A periodic tenancy or periodic lease is where, it doesn't say how long it's for, but it does tell you that rent is payable at a specific time, right? So it could be, a lease that is ongoing until the parties want to, one of the parties gives notice, but rent is payable every month. That is a periodic tenancy, right? A tenancy at will is pretty similar. It just means that, again, there's no period of time, but it can be terminated by either party at any time, right? So if landlord and tenants want to negotiate a more definitive kind of a lease, they should really have a tenancy for years because it defines the time period. A lot of them are renewable, at the election of either party and so on. But at least you know that for a period of time, the tenant, if they do what they're supposed to do under the lease, and the landlord, if they do what they're supposed to do under the lease, that it will run for a specific period of time. And the last one is kind of not even a lease at all. It is a holdover tenant situation. It's called a tenancy at sufferance. This is when a tenant stays on after the lease has ended without the owner's consent. This is the landlord's nightmare, right? The lease ended and the tenant refuses to leave. Sadly, it happens. The law in most states, including New Jersey, is that you can't use self-help. You can't go hire people and throw them out. You have to go to court, right? And in fact, there are like landlord-tenant parts, special jurisdiction courts where supposedly you can get a quick hearing. Supposedly, it would be a quick and fair process, but it is difficult when a landlord finds themselves in that situation because they have to go through a legal process to get rid of that holdover. Okay? I don't think you're going to learn anything on this next slide. It just basically tells you what the landlord-tenant relationship is. Okay? Moving on. Now we're going to talk about duties. Right? If it's an agreement, if it's a contract, shouldn't there be rights and responsibilities on both sides? And the answer is yes. So what is a landlord supposed to do for a tenant? Well, the landlord, the first thing they're supposed to do is give them what they promised them, which is the place that they leased, right? A duty to, quote unquote, deliver possession, meaning make it available to the tenant, sure. And then the duty not to interfere with the tenant's right to quiet enjoyment. That's just legal terminology. Doesn't mean that it has to be quiet. It just means that it shouldn't interfere with reasonable use of those premises, right? So a landlord may not interfere with the tenant's peaceful possession, use, and enjoyment of those leasehold premises, right? I mean, that's the minimum you would expect when you lease real property. What else? We hope that the property is livable, is safe, it meets local and state housing standards, right? And even things like that, it provides heat in the winter and things like that, and it doesn't matter who pays for it. What's more important is that it is livable and so on and so forth. And that brings me, I think, to the only case in this chapter, which was a case where it wasn't livable premises. Only last case, I've done just about every other case it seems today. Who's going to do the New Haverford case? Thank you.
So, one of the girls, I think she was a 30-year-old woman, she was a student, and then she rented this place to live, and then it had like different...
It was, what kind of a place? Was it a house? Was it an apartment building? Yeah.
And it had like different halls with the ceiling, bathroom, and kitchen. And then, is it that like the leaks were covered with black mold? And after a while...
It was pretty bad.
Yeah.
Yeah.
And after a while, she actually got sick from it. And
Well, when did the ceiling fall?
yeah, the ceiling collapsed and the water flowed over the whole floor. And she's saying because it was covered with black mold and orange.
It was
a
all.
bunch of white mold.
Yeah. Mold is not a good thing.
Yeah.
She actually spent the night once that happened, and guess what?
She couldn't breathe.
She got sick,
Yeah.
and really bad,
Yeah.
to the point where she developed asthma, all kinds of breathing issues. Actually had attention memory. Breathing in fumes like that can cause a lot of damage, right? So she went to court and she sued. And by the way, this tenant had given plenty of notice that this was a terrible place. In fact, the landlord moved her to another apartment, but they were not maintaining you're talking about what is a landlord's duty to maintain. This fell far short of that. So here she got some medical expenses and so on, but how much?
It was $28,000.
Right, but more than that, did the court give her any debt?
Yeah, they give her $1 million.
$1 million. And boy, that's huge. So case goes all the way up to the Supreme Court of Delaware by the company that actually manages the building. And what did they want?
They
wanted to pay.
Of 25.
They wanted to pay less.
Yeah, they wanted to pay less.
Right. So the question was, were they liable? Oh yeah. Right. And then the other question was the amount of damages to this graduate student appropriate? What does the court say? Supreme Court of Delaware. They said, yeah. They said, look, if a reasonable jury found that some 24-year-old student suffered legitimate and horrible health consequences as a result of someone negligently and really grossly negligently maintaining their premises, who are we to say that $1 million was too much and $250,000 would have been better? No way, it's going to stand. So, I mean, this case is kind of instructive in the sense that, yeah, landlords have a duty to maintain their premises, and just because, I didn't know that there was such bad stuff that could have, well, too bad, you're liable. And, so it's kind of a sad case. So again, kind of sort of just saying, what are, you have to give people that are premises that are fixed, safe, suitable for ordinary use, and if that is not done, what can a tenant do other than just leave? Well, they can withhold their rent if they wanted to. They can, if you're not going to fix it, we'll fix it, and we will deduct it from the rent. They can, even if you signed a lease for a year, you can leave after 2 months and have a reasonable reason for breaching that lease because you were, nobody kicked you out. It wasn't an eviction, but it might as well be a constructive eviction, because how could you live in a place that was so horrible to live in? And by the way, you could also sue for damages, as we've seen. So yeah, I mean, again, how else could I say it but to say this is a contract where a breach by the landlord allows a tenant to sue for breach of contract and get damages. Okay, so those are some of the simple things that a landlord owes to a tenant. What does a tenant owe to a landlord? Well, what is the obvious thing that they owe? Money, right? Because why would you lease anything? You lease things for money, right? So they have a duty to pay rent. If they don't pay rent, what happens? They can be sued for breach, not only for the month or two that they didn't pay, but if they signed a year lease or 5-year lease, for the for that time period. Now remember, you go back to things like, well, you got to mitigate damages, right? You got to find another tenant or things like that. But you could get damages for someone breaking their lease early for not paying rent. I don't think you need to know all this. I mean, it's there. It defines, like, there are different kinds of payments under a lease. A gross lease is just paying rent. But there are other types of leases which are referred to as net leases or double net leases or triple net leases. I could torture you and make you memorize all this stuff, but I won't. Because what it means is, in addition to rent, you might have to pay property taxes. You might be paying utilities. You might be paying insurance on that property and so on. But the point here is that know what kind of lease it is, what you sign up for. If under the lease you are obligated to make more payments, then that is a private contract. It is an agreement between the two parties that the tenant has to live up to, right? What else should the tenant do? Well, the tenant should not use the premises for illegal, obviously, purposes, or what are referred to as non-stipulated purposes. What does the word non-stipulated mean? Non-stipulated means not agreed to. Right? So you can't, run a business out of those premises if it's meant for residential use. Even if you bought it for business purposes and you say you were going to use it for an accounting firm, you can't then sublease it for another purpose, right? That wasn't what you leased the premises for. Duty not to commit waste, which means not to cause unreasonable wear and tear, to use it as a reasonable person would. Duty not to, quote unquote, disturb other tenants. And that just doesn't mean loud noises. It could mean, foul odors or things like that, right? I mean, if you're in an apartment building or if you're a tenant in a business complex, you have to, be respectful of the landlord's other tenants. I mean, they can't be losing business because, you don't throw your garbage out and you leave it out there for 3 days, right? That's your responsibility as a tenant to the landlord. Now, what if the landlord decides to sell the property, but they also have given a lease to a tenant? So a landlord can, as the owner of real property, do whatever they want. But the default rule is that the lease goes with that sale. So if I own an office complex, and if I decide that I want to sell it to another company, but I have 5 tenants renting space, then, and they have 2 years left, 5 years left under their lease, that, the new company assumes that lease, and that's fine. But it is possible that my lease could have had in it that said something like, if I decide to sell the property, your lease is terminated, right? The point here is that these are private arrangements. A lease is a private arrangement, a contract for sale is a private arrangement. You have to look at the terms of the contract to see what it says upon a transfer, right? You can't assume that your lease will continue. You have to look to see, did it say that upon sale it terminates immediately? Possibly. Then the landlord just has to give you notice, and guess what? You have to find another place to rent, because that is not a breach of contract, right? So again, these are important things to remember, that contract law will always follow us, right? Okay, what if you are the tenant or the lessee, and you have a 5-year lease and you're on year 3, but you want to give your lease to somebody else? Because if you don't, you're going to be in breach of contract, right? I mean, you have another 2 years remaining on the lease. So remember, we talked about assignments. Can a contract be assigned? Answer, typically yes, but what if there's an anti-assignment clause, right? So it depends. It's, if there is no anti-assignment clause, it means that a tenant can basically assign his or her rights and duties under the lease to another party. So if I'm a tenant and I'm renting space in an office complex and I have 2 years remaining and I need to move my operations to another state, I can find a good enough tenant that will take over the remaining 2 years left on my lease, right? In that case, I have made an assignment, and this should be sounding, kind of familiar, because we just did assignment after the midterm. All that means is that the assignor, the tenant who transfers their right under the lease to somebody else, have transferred the 2 years remaining on that lease. So whatever rights they had under that lease have been transferred if the lease allowed for it, right? Maybe that the landlord had negotiated the right to approve, which could mean that they may have to approve of the new person I find. That's fine. Why? Because they want to make sure that they're going to be able to pay the rent and things like that, right? So here, the new tenant, the assignee, will just pay the rent to the landlord, and they assume all the rights and responsibilities that I had as the original tenant, because they assumed the remaining 2 years. And by the way, if there was an option to renew that lease for another 5 years, the new tenant stepped into my shoes and has the same option, right? That is an assignment of a lease. But leases can also be a sublease, right? A sublease is not the same thing as an assignment, because in a sublease, the tenant is not transferring all of their interest, they're only transferring some of their interest. And for those of you that have rented in the past, did you ever do a sublease arrangement? Nobody did? Right? So what if you've signed a lease for a year, right? And it turns out that during the summer months, you're not going to be on campus. And you want to find somebody else that could pay the rent for those 3 months, because why should you pay rent if you're not going to live there, right? That would be a sublease, right? So a sublease is an arrangement where the tenant transfers some of their rights in a lease to another party. And it's the same sort of thing. Look, if the lease agreement says assignments and subleases are not permitted, then that's what you're bound to. But if they do not, then it is possible for a tenant to sublease to another tenant, and that would be fine. The difference here is that, how in an assignment, the new tenant has a relationship with the landlord because they're stepping into the shoes and the original tenant is going out of the picture. In a sublease, no legal relationship has been created with the landlord. The landlord doesn't care, right? They just want to be paid. Here, it's an accommodation if the lease allows. For example, I rent an apartment from September to the following September, right? I want to come back in following September and start living in my apartment, but during July and August, I have an internship abroad. All right, fine. I sublease to my friend because the lease doesn't prohibit a sublease. During those 2 months, my friend just pays me rent and I still keep paying the landlord, right? Happens all the time. Come the next September 1st, I'm in the next year, I'm a sophomore now, whatever, and I'm just gonna continue living there, right? So that is a sublease arrangement, but it doesn't create a legal relationship between the landlord and the new tenant. It just allows the tenant to transfer some of their responsibility during the term of the lease. Everyone with me? All right. Next couple of things are just to kind of make you aware of other things under landlord-tenant sort of situations. And the first one is rent control. Rent control is basically, look, it's a private arrangement. Typically, landlords can charge market rent, but there are places in different cities where certain buildings are deemed to be rent controlled, which means rents can only go up a certain amount. And this has been challenged. The cases have gone all the way up to the Supreme Court, and the Supreme Court has said they're legal. And the reason for that is in cities like, for example, New York, cities like Chicago, LA, the idea is that, look, it's okay to have some government regulation. Because otherwise, if you had no rent-controlled properties, how would middle-class people ever be able to afford? I mean, anyone check out what the going rents are in New York City these days? I mean, it's mind-boggling, right? But there are some areas where there are rent control, meaning that's not cheap, but it's at least affordable to people that don't make, $1 million a year, right? So again, the courts have said that that kind of regulation is legal. Not, for some percentage of housing. And the other quick real thing, and don't memorize all of this, it just means that there are laws both at the federal level and even at the state and local level that basically says that there cannot be discrimination when it comes to selling property, when it comes to leasing property based on factors such as someone's race or religion or even disability, right? I mean, ADA accommodations and so on for larger buildings and larger office spaces and things like that. And those are just anti-discrimination laws. And just to be aware of them, you don't have to memorize any of these particular laws. I'm sorry, I've already talked about the Disabilities Act and so on. And the last thing I'll really mention very quickly is something called eminent domain. Eminent domain. So what it does is that it actually allows the government to take private property. Really? Oh my God, that's awful. But what it means is that, look, if government needs to purchase private property from someone, and even if they're not wanting to sell it, all the government needs to show is that they need that property for a public use, which used to mean things like we need to build a highway or we need to build schools or things like that. And that doesn't mean that your private property is taken away. It means that you're going to get market price or maybe even more than market price. But if you remember at the end of this chapter, there was sort of a controversial case that the Supreme Court decided in Connecticut. This is going back now maybe 7-8 years. It was the Kelo case, K-E-L-O. Just an interesting case for people to be aware of in the city of Connecticut. Parts of Connecticut, New London were pretty depressed, and the city decided that they were going to do all kinds of economic development, build mini malls and apartment complexes and things like that to bring business in, to provide jobs and things like that. And good idea, but the thing was, pretty much a lot of abandoned houses and things like that, but in one part that they wanted to build on, it was a pretty decent area. And the property owner said, we're not selling. You cannot take our land, even if you pay us a good price, because you're not using it for quote unquote public use. Building a mall or whatever is not, economic development is not public use. And the case went all the way up to the Supreme Court. And what do you think the Supreme Court said? Controversial decision, 5-4, economic development is public use. So it really expanded the definition, and a lot of sort of consumer groups are very unhappy with this decision to this day. But what it meant was, yeah, it's possible that it doesn't have to be a highway or things like that. It could be just because we think that this area would be better as commercial property, and you have to sell your land. So, it's kind of an interesting case because we think under the Constitution we have the right to property, blah, 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 blah. But eminent domain is an exception to that rule, okay? Of course, the point I want to make here is that you have to give property owners just compensation, meaning you can't just take property as eminent domain. You have to give those landowners, more than fair price for the land that the government would like to use for whatever purpose it needs to use it for. See, as promised, we are done early.